Hello, and welcome to this Lexology webinar. My name is Patrick McGauley. I'm an editor here at Lexology, and I'd like to thank you all for tuning in. We have a really great presentation lined up for you today looking at data governance, transfer, and protection trends in multi-jurisdictional investigations. Our expert speakers today are Francis McLeod, Greg Mason, and Doel Carr from Forensic Risk Alliance. Francis is a founding partner at FRA and head of its US offices. She is a former investment banker with over 26 years' experience advising clients on sanctions, anti-corruption, fraud, internal control, asset tracing, and money laundering issues. Greg is a founding partner at FRA and head of its e-discovery and IT divisions. His expertise lies in database architecture and programming, software design, mass data analysis, data mining, and data forensics for investigations, disputes, and litigation. Doel is a director at FRA's New York office. She has been a practicing attorney for over 18 years with significant experience as a compliance officer. So there are just a few general admin points to mention before we start. First of all, please use the online question tool to post any questions that you have, and I will address them to our speakers after the presentation. Secondly, if you have any audio-visual problems during the presentation, please let us know by using the online question tool, and we will do our best to resolve them. And finally, just to note, a recording of this session and the PowerPoint slides will be posted online, and we will send a link to all webinar attendees. Please use the link and send it to any colleagues who you think may be interested in today's presentation. So without further ado, I'd like to hand over to Francis to get things underway.
Thank you, Patrick. My name, as you've heard, is Francis McLeod. I'm one of the founders of FRA. We were set up 20 years ago. It's actually our anniversary November this year. But very much the genesis of FRA came from Greg and my experience in dealing with data transfer and data privacy issues. We met well over 20 years ago working on the Swiss Bank project, looking at dormant Holocaust-era assets, where obviously we came up against Swiss banking privacy constraints and ended up having to design an environment that allowed us to match Holocaust-era accounts within individual banks without even taking the data out of those individual banks and violating Swiss banking secrecy. And subsequently, we've had a great deal of experience dealing with data governance and transfer issues in all of the matters that we work on, both as forensic accountants, but also as data governance consultants. We've long been advocating adopting a highly circumspect and nuanced approach to data governance, particularly in the context of responding to regulatory and white-collar investigation and litigation. We have navigated a gamut of challenges surrounding the identification, collection, analysis, and ultimately transfer of international data, often of a very sensitive nature. And as we go through the webinar, we'll be giving you some examples of how we've done that and the approach that we take when we are addressing these issues, either when, as I've said, in our own work as forensic accountants, we're needing to access data that might be in a variety of different jurisdictions and respond to a variety of different enforcement and government agencies, but also as we assist our clients as they respond to investigation and litigation, or even as they're just undertaking internal investigations or other activities. And with that, I'm going to hand over to, I'm going to continue talking. I'm going to talk a little bit about data governance, transfer and protection trends. I think there's always been a great deal of complexity just to do with the conflicts of law that exist, but they seem to have reached a very clear sort of trend of an emergence of conflicting global trends that affect data privacy. Obviously, if you're looking at this from a context of investigations and big ticket litigation, you're also trying to look ahead over a number of years. I mean, frequently we'll see that large investigations can last north of 5 years, sometimes far beyond that. And so whatever you're doing when you're looking at how you might want to address data transfer issues, you're trying to look forward and see what decisions you're making today, how they might change and colour the outcome of the litigation or investigation that will not be finished within several years. So just looking at this chart up here, you're seeing these conflicts emerging very, very clearly. So obviously we've got the GDPR, which came into effect a year and a half ago, which is the European-wide sort of common law regulation that looks at protecting data protection for its citizens. The Cloud Act, which was introduced under the Trump administration, which gives very, very wide-ranging access rights of the US government to pretty much data anywhere in the interest of protecting sovereignty and also looking at sort of a variety of different activity. And then also the Chinese cybersecurity law, which looks very much at needing to keep data that originates in China, and there are very broad-ranging rights that the Chinese government grants around audit of that sort of data. So that poses a great deal of challenges to companies acting in the global environment, which frankly most of them are. You've also seen, obviously, as a result of government surveillance, both in the UK and the US, and information flow, and obviously some of that has caused a great deal of concern. And then also the daily news that's hitting our newspapers and on the internet around the increased enforcement of cyber breaches. So when hackers come in and make data available more broadly, and obviously we're looking at the Google and the Facebook challenges that are going on at the moment. So the world in which corporates and in fact consultants to corporates operate these days is increasingly complex and increasingly requires that one navigates these conflicts of laws in a way that is compliant, and that is occurring in a context of increased cybersecurity risks as hackers, both government funded and private, are out there marauding and trying to get into corporates. And so the need to protect and control data flows is probably more important today than it has ever been.
Right, and considering these trends in data privacy can put strains on running an investigation smoothly. We at FRA, we've had experience working on projects that would be impacted by these transfer and protection trends. For example, involving several EU jurisdictions, Switzerland, the UK, and the US, or working on projects that involve multiple law firms where they may have restricted access outside the appropriate jurisdiction, or dealing with data privacy regulations like the French blocking statute or the German blocking statute, Swiss banking secrecy, and more recently, as Francis was talking about, the GDPR.
We can move on to the geopolitical regulatory environment slide.
If I can find it.
The arrow work.
Yeah. There we go.
There we go.
Right, and so in the past few years, we've seen significant developments in data privacy regulation, and today's regulatory environment can be very strict and often conflicting. So if you consider the recent safe harbor invalidation, which was driven by the Snowden revelations, where the EU CJ deemed that personal data was not adequately protected under this certification, onto the Privacy Shield programs, which is due to the safe harbor repeal. There's more rigor in these programs for the EU and Swiss, but there are limitations and certain controversy, primarily based on the fact that they are self-certification. It's a self-certification program. And then the GDPR, which, as Francis was talking about, came into play in May of 2018, and this regulation has serious teeth, and primarily because of the draconian fines of up to 20 million euros or 4% of annual turnover. Global annual turnover. And there have been dozens of fines, and most notably, in recent press, you've seen that Marriott and British Airways were fined in total over 300 million pounds. So the fines are pretty serious there. And then you have the various blocking statutes and secrecy laws that you have to deal with. And then you have conflicting laws such as the Cloud Act, which allows U.S. authorities to request data from U.S. service providers wherever in the world the data is stored. And then there's the unknown with Brexit, where there's a trend for certainly we've seen clients requiring data not to be maintained in the UK because they just don't know what's going to happen there. And as Francis was talking about, the China cybersecurity law, where it was put in play for the purpose of increased cybersecurity, national security, and to protect the rights and the interests of their citizens. However, there's a lot of controversy amongst, in particular, foreign companies where they feel that it's a mechanism for the Chinese government to gain access to commercially sensitive information, whereas they have to they have to put their data on Chinese law-regulated servers, and they could be subject to various spot checks, which would give them access to very sensitive information.
And I think this is a very interesting point we make here, where people generally tend to focus a lot on the GDPR today, but what's interesting is that this regulatory environment has actually all these other statutes to think of. So you spoke about the blocking statutes, where actually the country shields companies in its jurisdiction by prohibiting them from, respecting sanctions of other foreign governments. You think about banking secrecy or state secrecy, you're taking this to a different level, where you're looking at specific types of data which need further restrictions. And you need to think of what laws are in place in those specific countries. The other thing that's very notable is when you're handling investigations continue for a period of years. So one really has to be prepared for what's about to come. And what we see as a trend, generally, apart from the US and the EU itself, the US has a new privacy law that's coming up and coming into effect in 2020. That's the California Consumer Privacy Act. That seeks to protect the privacy of residents in California. That is very much akin to the GDPR, but it actually requires it has additional nuances, really. In addition to that, Brazil has a law coming up in 2020. India has a draft bill that's out, which again, very much like China, talks about data localization, where the government is seeking to require an active copy of the data to be stored physically within the country. And every cloud provider that sets up there needs to actually set up a data center within the country. And that, as you can imagine, creates another level of complexity in this entire environment. So we have to think of not only which countries that you're doing business in, where the investigation comes up, but also forward thinking as to what's about to come, so that you're prepared for what type of compliance one needs to think of when issues arise.
Right. So, I mean, this basically says that data governance and management is becoming more and more complicated. And as evidenced by recent headline-grabbing cases where the ICO particularly has been active, and it may not necessarily relate to an actual breach, but related to protective measures. So, for example, Marriott was fined £100 million due to failure to undertake sufficient due diligence through its acquisition of Starwood Hotels Group, where the breach had occurred 4 years prior to the acquisition. British Airways, another example, where they were fined $183 million due to poor cybersecurity arrangements on their website, which allowed exposure to about 500,000 customer records. So the focus is on not just breaches, but proper due diligence, proper protection, proper structures in place to protect data. And in the U.S., perhaps surprisingly, the U.S. has been picking up its game with regard to protecting people's privacy, not just with the regulation that's coming into play in California, but the recent Facebook fine of $5 billion levied by the FTC against Facebook for mishandling users' data. So regulations and their enforcement will impact on the future of data governance, and we're seeing a lot of activity in this area. Go to the next. Here it is.
So looking ahead, there are a few things I'll mention here. One is the tremendous reliance on technology for businesses across the board. Even a moderately sized organization can end up storing significant amount of data. The other thing is cloud storage systems. That adds an additional complexity. One needs to know where the data is being stored. Globalization, that's definitely here to stay, and remote working conditions. So when you look at that, the volume of data that businesses rely on, as well as globalization together, you're looking at multi-jurisdictions that one needs to be prepared for. You're looking at a very active regulatory environment. Data protection laws are only just coming in at this point. Countries are just joining what the EU has been doing for several years. We absolutely have to be prepared for that future, and to my mind, it's really just the beginning for the years to come and what to expect. Companies are thriving on user-generated data. Businesses are modeled on that, and we have to be prepared for where that data is based. Should an investigation arise, should the company have to respond to an enforcement agency, what needs to be done next?
Right, and I think that's something that we've seen, way before the introduction of GDPR and some of these other laws. Obviously, the French blocking statute and the Swiss blocking statute have been in place for a very long time, but we're seeing some of those even being beefed up, because I think increasingly there's a perception outside of the US of the reality of the long reach of US jurisdiction. And so, you see sovereign states like France wanting to protect its companies from, investigation by foreign bodies. But it means that in this world, as Doel said, of data proliferation, all of the cyber risks, the fact that it's here to stay, globalization, that there's a whole decision tree that companies are faced with addressing whenever they are responding to either litigation that's multi-jurisdictional or investigation. And clearly, they may want to cooperate, but how easy is cooperation to do without triggering a penalty, for example, for breach of GDPR? So one of the things we are increasingly asked to do is to give advice around data governance and to almost look at which the most sensitive data sources are that companies are handling, how do they address that? And it's increasingly something that is one of the first conversations we have when we're engaged as forensic accountants, or where obviously it's the case when we're engaged on the e-discovery side, but when we're engaged as investigative accountants, one of the first questions is, what are we going to do around the data governance piece, and how can we assist the company in developing a plan that is going to be in some way, it's never going to be 100% compliant, but at least is largely compliant and defensible, because that's the whole idea, is if you were to have a conversation with the Data Protection Authority, which frequently you do, and you have to notify them when you are going to be undertaking developing a solution, you want to do something that is clearly defensible, that's not showing that you are cavalier to the constraints that GDPR, for example, imposes. So these are a couple of case studies of matters that we've worked on. The first one was actually a solution that we developed, and I can let Greg talk about a little bit because he was partly or largely the architect of it. So it is a multi-jurisdictional investigation involving a multinational aerospace and defense corporation. So obviously by de facto, there is extremely sensitive data involved, with individual nations purchasing defense equipment from this company that clearly has highly sensitive information within the company. It was a solution that was developed actually pre-GDPR, because we started on that project before GDPR came into effect. And again, this is to Doel's point of, if you are launching an investigation or responding to a government inquiry, you're doing your very best to develop a solution that's going to be fit for purpose for the duration of that investigation from a data transfer perspective. And I'm pleased to say that we conceived of this pre-GDPR. We're obviously now in a GDPR world, and we were able to develop something that was compliant, that both addressed data privacy issues, state and national defense issues, obviously IP protection issues, highly sensitive information around the technology of this particular company, both in the aerospace space as well as in the defense divisions. Extremely large, complex company, and multiple law firms that we were dealing with, north of 7 or 8, you want to say, Greg?
Yeah, up to 10 now.
10, and the other thing that we developed here, and I'll let Greg describe the sort of the technology solution, was that we had work streams. We developed a solution that managed the access of data depending on which jurisdiction the law firm was responding to, managed the who had access, provided a full audit trail, controlled information flows even within the in-house team and the investigation teams at the various law firms, and our own forensic accounting teams that were working on it. But I'll let Greg describe what we did in terms of being able to safeguard the nationally sensitive data, and also talk about what we did from a data protection perspective, and then talk a little bit about reporting in order to validate the approach that we took to the enforcement agencies that came into play, which would include the Serious Fraud Office, as well as the Department of Justice, as well as the French authorities and the PNF, correct.
Right. So as Francis was saying, some of the challenges that we were to deal with potentially nationally sensitive data, and also personal and private data with several jurisdictions within the EU. And in this situation, we had to set up what we call mobile solutions that were air-gapped and installed on the client site so that it prevented any sort of external access. And we, as the implementers of the solution and the attorneys, were not allowed to view the data that was potentially nationally sensitive. So we had to set up a solution that allowed the client to review the data and segregate the nationally sensitive information, and then release what was referred to as the potentially relevant information, but doing it in such a way that it gave comfort to the regulators that they were not hiding any potentially relevant data. And then all that information was centralized to what we called an unrestricted location, where that data could be accessed, again, with various restrictions in the EU and with various law firms, and then putting in additional safeguards to that centralized data such that the potentially private data could be segregated, and then also giving comfort to the regulators so that we could employ computer algorithms to deem whether or not the private data was truly private or potentially relevant. So all sorts of complications, multiple jurisdictions, data sensitivities, and just leveraging off of technology to help assist provide a solution. And so moving on to, or do you want to add something?
Well, I was going to just add, I think a pretty relevant case study. So the multinational transfer engineering company case study was actually pre-GDPR. And so some of the solutions that we developed for that would not necessarily be fit for purpose under GDPR. For example, when we were accessing information of French nationals in France, well, actually just employees based in France, we had developed a consent protocol. Under GDPR, that consent protocol would probably be, even though we were very specific about what we were collecting the data for and how we were going to use it, so we could argue it was informed consent. I think we would take a different tack today, just because having informed consent in a way that stands the test of time is quite a difficult thing to do. And obviously, you've also got people have the right under GDPR to withdraw their consent as well. Right. So we would have probably taken a more conservative approach in the post-GDPR world. Obviously, that matter settled many years ago, and it was acceptable to, we didn't have any complaints from employees, nor was there any sort of industrial issues or employee relations issues. We'd take a different tack. One thing I just did want to touch on, because I'm quite proud of it, is we're currently working on a monitorship of a German company, and in the post-GDPR world, and that's a company that is very focused on being compliant. They obviously don't want to attract the sort of giant fines that Greg was alluding to. And so what we've done there is develop a protocol for creating 2 different data rooms to allow for data review. So obviously we'll be putting requests into the company to give us responsive documents so that we can test their compliance environment, and it's an environmental emissions related matter. What we've done there is that all of the data is gathered and collected and remains in the EU. We put it in our data center in Paris, so that it stays within the EU, only available for review there. It's simultaneously translated by software, so it can be reviewed by non-native German speakers as well as native German speakers. To the extent that we then want to take that data and use it either for reporting to the Department of Justice, or we want to reference it in our monitorship report, we will flag up the documentation that we want to rely on. The company will then redact that of all personally identifying information, or PII, and move it into a second data room, which is accessible from the US. because we obviously do not want to transfer anything that has PII in it or anything that is commercially sensitive or whatever else it is into the US, where, first of all, obviously it could be provided to the Department of Justice or become discoverable. So we have the second data environment, which is accessible from the US, and that all of that information resides in that in a redacted form. The data room number one is completely locked down within the EU with very strict access rights and a full automated trail. We presented this solution to the German Data Protection Authority, thinking that they were, and by the way, we're hearing through the grapevine from our clients and the various data protection officers that we know that all of the data protection authorities in Europe are incredibly swamped at the moment, either with companies asking them for guidance on certain things and or with them assessing various matters to see what they're going to do with them. Rather surprisingly, we got a response back within a couple of weeks that the approach we were taking was acceptable to them. So we're quite pleased with that. That's something, the methodology we're going to be applying again and again as we help corporates respond to monitorships, investigations, and litigation.
Right, and just touching on the example of that Francis was talking about, where we did get consent. We did adhere to the French blocking statute.
Correct.
Technologically, so we did maintain that data inside of France. It was all process hosted and reviewed there. So I think from a GDPR perspective, we were compliant from a technological perspective.
Correct.
And then moving on to technology solutions, these obviously can assist in navigating the complexities around data governance. And we at FRA, we rely heavily on these solutions. So just to touch on some of these areas, the key is understanding the data landscape and implementing a rock-solid audit trail with complementing solutions to ensure that it is maintained. So if you look at chain of custody and forensic acquisition, which underpins a successful investigation, ensures proper tracking of data, prevents any spoliation of relevant source data, and is a mechanism for ensuring regulations relating to handling private data can be followed. And then hosting data, jurisdictional consideration is incredibly important for collecting, processing, and hosting data, ensuring that you have proper environments that are in place. In some of the examples that we gave, you have data centers that are in the appropriate jurisdiction, or in some situations it might be appropriate to have a mobile solution, and even beyond that, a mobile solution that is air-gapped and not connected to the internet. Segregation of sensitive information, either privileged, confidential, or private. This can be achieved through technology. We rely on that heavily, and it could be something as simple as search terms or based on standard private terms, and in some instances, specific custodian segregated folders, or onto complex searches based on more complex data analytics, such as clustering, threading, or assisted review. And some examples of how we've employed this on specific projects, there are various tools that we put into place. For example, cross-border deduplication, and this comes into play in cases where there's multiple jurisdictions involved. And then touching on what Francis was talking about, the example case with the German Data Protection Authority, redaction. So there's several ways you can do this. You have a lot of software tools out there that allow you to manually redact while you're reviewing data, and then you also have tools out there that allow you to automatically redact, which we have employed, and that can be based on specific terms or specific patterns. And various different jurisdictions have different classifications of what is considered to be personally identifiable information. For example, in Germany, IP addresses are considered to be PII. So with these auto redaction tools, you can put in various patterns, and it can automatically go through millions of records and automatically redact. There's obviously a separate review to confirm that you're redacting everything. And in the example that Francis provided, where you have multiple data rooms, for example, if you're pushing data that's being redacted to a non-secure or a data room that is accessible from outside that jurisdiction, you can just verify that no private information or sensitive information is actually being disclosed.
I think we're always keeping an eye out for technology that is going to help us assist this. Obviously, you're all hearing the buzzwords around AI and how they're going to revolutionize the sort of document review and the whole e-discovery world. There are some really interesting tools out there. There's a lot of investment going into this space, and a lot of investment going into essentially tools that are going to help people comply with these various regulations. But clearly they have to be calibrated with the expertise of people who understand, the best practices of data governance and stay abreast of whatever the legal requirements are. And we'll talk a bit about why it's incredibly important to find the right lawyers to partner with to get the right legal advice to stay abreast of developments. But certainly we're seeing on the redaction side of things, it's going to be absolutely critical to have tools that are robust and can assist that, because as Greg was alluding to under the aerospace and defence company example, we're required to report out to the enforcement agencies, the metrics that will underpin or demonstrate compliance with obviously furnishing them with responsive data while not being in breach of data protection laws. And clearly, there is some suspicion around, I've classified that as private or personal, when actually it's a document that would implicate the company or implicate an individual in illegal or criminal behaviour. So the ability to be able to deploy these tools and to have that audit trail and to report out in a way that is defensible to the enforcement agencies and show that there are no shenanigans going on, that people are using GDPR or any other data protection or other regulation to sort of prevent them from getting access to information that they require for their investigation is really critical.
So no pun intended, but that's a lot of information to process. I think we need to, take a step back and, the problem statement's kind of clear. You have conflicting laws, multiple jurisdictions, a ton of data, and today you have in-house counsel and in-house compliance professionals really grappling with just putting together a compliance program to just have, for data privacy and data security. And what we're talking about here is, what do you do when an investigation comes your way? An immediate response is, how do we preserve documents? How do we collect documents? People are thrown at the problem. And there isn't really one solution for all of it. What we would like to discuss today is just a few measures that one could consider as some top priority items, I'd say. We look at 4 today. The first being data mapping itself, and we'll talk about that in a little more detail. I spoke about collection and preservation. This is really a very critical time in any investigation, and it's very important for in-house teams to actually consider how that should be done effectively, looking into where the issues are arising or could arise. And then, of course, looking at your overall compliance program, training and reporting up is always material in whatever type of compliance you're dealing with. And then finally, having a strategy in place regarding data transfer.
Right, and talking about the data mapping, the strategy is vital, in particular with the complex multi-jurisdictional investigations where you have to consider data privacy and data sensitivities, as based on some of the regulations that we've already talked about, the EU data privacy around GDPR, blocking statutes, in the case of banks, sensitive banking data or nationally sensitive state secrets. So what data is being considered? There's several topics here. You've got the type of data, whether it's personal or other sensitive data, or the format of the data. It could be various forms of communication. It could be emails, it could be text, it could be on application like WhatsApp, it could be data on personal PCs or shared data on servers. So it's understanding the landscape and getting your hands around the potential data that might be relevant for an investigation. And then also what's important is jurisdictional considerations, EU, the China, US, and in particular if you have multiple jurisdictions, which is more and more common with the global economy. So asking questions like, where does the data reside? Does it need to stay in country? Can it be moved? And are there any competing data privacy regulations, the EU versus the US, for example? And then considerations of a data mapping strategy directly impact the next stages of the investigations, which is on to what Joelle was talking about. You have your collection and preservation.
One thing I'd add Greg, regarding data mapping, I think this is another area for collaboration. You require legal and compliance expertise there, but you absolutely need your IT support as well. You need people with expertise in that area to really understand where the data resides, and especially in today's age of cloud service providers, understanding where the data is being stored and even where backup data is being stored. Very often your procurement function or your procurement department may not realize the relevance of it at a later point of time. But, again, providing the training to them to think through that. So again, just getting the teams together and making sure the right people are at the table when they're going through this data mapping exercise.
Right. Very important. And then collection, and as Joelle was saying, collection and preservation is critical in its post-data mapping and what we refer to as identification and e-discovery lingo, ensuring that potentially relevant data has been preserved and using mechanisms, various tools and mechanisms, such as backup and retention policies, but ensuring that they're being adhered to, and where relevant, a proper litigation hold notice procedure, but not just ensuring that it's been served properly, but it's tracked and followed up on. We have some examples where litigation hold is not a familiar practice outside of the U.S. And then risk management tools that you can leverage off technology for maintaining information. So there's archiving mechanisms like the lit hold option on Microsoft Outlook, or there's Enterprise Vault. So there's various mechanisms that you can rely on to obtain and preserve and collect data. And then once you have that data and it's being preserved properly, collection must be done in a forensically sound manner. And I can't say this enough, but it's important to maintain a comprehensive audit trail, leverage off chain of custody forms. And this is critical because it underpins a successful investigation, ensures proper tracking of data, prevents any spoliation of relevant source data, and is a mechanism for ensuring regulations relating to handling private data can be followed.
And we see that frequently. Obviously, in a e-discovery is immensely costly, and obviously we talked about the proliferation of data and how it, even though the way it's charged for is constantly under price pressure, there's more and more data out there, and as Greg said, from non-traditional sources as well. The email is increasingly not the source of the smoking gun information. It's frequently chat room data or other things, particularly when you're looking at sector-specific solutions as well. For example, in financial services, it's highly likely to be chat room, Bloomberg, other kinds of data as well that needs to be collected. But the preservation piece goes to the potential success or failure of an investigation. And we can increasingly ask by clients, because of the cost point, can we do this ourselves? So the point to that is back to Greg's point, is theoretically you can, and maybe you could, but clearly somebody needs to be supervising, checking, being able to validate that whatever methodology is applied is forensically sound. And frankly, we're frequently called in when they've attempted to collect their own data and it's gone wrong, or they haven't identified all the sources correctly. So having somebody expert either in-house who's been through this before, or who's partnering with an external provider that's really expert is really quite critical. Training and escalation. So I think this is really around making sure within corporates that those involved in the investigations and data identification and data transfer are up to date on training, and they understand what the data transfer protocols are, and they understand what data privacy regulations and other applicable regulations come into play. I've actually just been through this myself in-house as we engaged on the monitorship I was speaking about, the German one. We had team-wide training for everybody on our team involved around GDPR, around the protocol that we were going to be utilizing with the various data rooms. There are written protocols that people can refer to. We also trained the law firm that we're partnering with, and we trained people in-house at the company to ensure that they were also up to speed on exactly what it was we were going to be doing, why we were going to be doing it. And we'll have refreshers periodically to make sure that people are still aware of the risks and following those protocols as well. So very, very important indeed, because you just don't want something to go wrong as a result of human error or someone not quite understanding what they're obliged to do. Should something go wrong, then clearly there need to be escalation protocols in place, just as there would be for any other type of compliance-related issue. There are quite strict rules in place as to how long you have. For example, if there is a breach of data protection law, I think it's 72 hours. And obviously, during that period, you need to do an investigation to work out what happened, how egregious it is, what PII, for example, was transmitted, and declare that to the relevant data protection authority. And that goes back again to the defensibility. So understanding, mistakes do occur, but that you've identified them and shut them down as quickly as possible is going to be key. And then I think we've spoken about this before. It's incredibly important to have appropriate counsel in each jurisdiction that understands the nuances of that particular jurisdiction's regulation. Much as we're all complaining about GDPR, there is a sort of beauty to it in a way, because it has put a common framework across the whole of the EU, whereas in a pre-GDPR world, we were dealing with each country within the EU specific regulation. So there is some comfort there, and I suspect we'll all get more familiar with it, but there's still a lot of unanswered questions as people work out how they're going to navigate it. And then also, in addition to local counsel, engaging data transfer experts that can help you deliver the practical solutions that comply with the legal advice that you've had. Data transfer strategy, we've talked about the importance of formulating a strategy that also has a longevity to it. So obviously you've got to work out what type of data it is, where it is, are there data privacy issues, are there other constraints? So we've talked already ad nauseum about banking secrecy, state secrecy, blocking statutes, and obviously security, because there are hackers out there, both state-sponsored and private. And then talk about, have a decision made with the legal team, the data transfer experts, local counsel, whomever needs to be involved. IT, as Doel said, is understand where the risks lie, and are you prepared to take the risk of taking an untested or controversial data transfer decision. We never use the safe harbor mechanism, because we never felt that it was defensible. Partly, yes, we did self-certify ourselves.
It was a very easy certification to achieve, $100 and 24 hours later.
Yeah, but we decided that we would, err on the side of keeping the data in the jurisdiction of origin, really being very, very careful about what data was transferred out, and really transferring the minimum out, which is to control the risks associated with large data transfers outside of the jurisdiction of origin. And as I've said, consult the experts to ensure that you are doing something that's appropriate, and think long-term to the extent that you can. Be as conservative as you can, and think about what the life cycle of this investigation or litigation looks like, and weigh the risks associated with doing that.
Right, and I think our approach, speaks to what Francis was just mentioning, trying to keep as much within the country, avoiding transfers where possible. But overall, I would say, like most other areas of compliance, this is a multidisciplinary approach that's required. One has to partner with the right type of experts to make sure that this is being done right. So working alongside legal specialists, in-house counsel, data protection regulators, to really come up with what works in that particular situation. It's really a customized solution. It depends on the jurisdiction, where the problem has arisen, which countries are involved, where the data resides, the maturity of the company's data protection program, and their technology infrastructure as well. So a number of factors go into what the approach should be. Again, very much like any other compliance field, no one size fits all. It needs to be customized. And the importance is really to, I think, get the right people in early on and have a strategy in place ahead of time.
And then I think that takes us on to questions.
Hi everyone, this is Patrick from Lexology again. So I'd like to thank Francis, Greg and Doel for a really great presentation, and we'll now get them to field some of the questions that we've received. So just as a reminder to any attendees who haven't sent through their questions as yet, please feel free to send them on now using the online question tool. So as a first question, are you seeing an increased enforcement of data governance laws beyond the headline grabbing cases? And if yes, what do these look like?
Yeah, so the answer to that is yes, absolutely. I mean, we've seen, specifically related to GDPR, an increase since it came into play of May of last year. There were several cases. There's dozens of cases that I'm aware of, and they range anywhere from as small as $5,000 up to close to 200 million. The headline grabbing cases that we had mentioned earlier, and these are being driven out of various locations, not just the ICO in the UK, but the Netherlands, Spain, France. CNIL has levied some fines. Lithuania, Poland, Denmark, Hungary, Austria. So we're seeing a lot of activity around, violations and fines being issued to some firms.
Many thanks, Greg. Francis or Doel, do you have anything to add, or can we move on to the next question?
I think Doel's a former compliance officer, probably has something to say. I mean, it's definitely the fear factor in corporates has gone up a lot. I think partly that obviously the headline grabbing, but I think also this sense that there is real enforcement going across a lot of different jurisdictions. So you're seeing certainly people treading much more carefully than they were a year or so ago, and it definitely, in terms of sort of risk awareness, it's definitely moved up. I think, cyber breach is probably number one, but this is coming down, I think in the sort of top 5 concerns of compliance officers and frankly, I think CEOs.
No, absolutely. I think one thing that contributes to it is the uncertainty, and people aren't quite sure as to what is expected of them, and you see people grappling with what is required as far as their program goes. So are we GDPR compliant? Are we compliant with all the other different statutes in place and what's about to come? So to my mind, it's a lot of in-house activity as well, in addition to having to respond to questions from regulators.
Many thanks, Francis and Doel. Our next question is, how do you take a pragmatic approach to data governance, given that it often needs to be balanced against commercial needs and stakeholder engagement?
Well, one has to carry out a risk assessment. To my mind, when one is faced with that kind of a quandary, you start with a risk assessment. The way one can actually support the risk assessment is actually carrying out a data mapping exercise. You are in a stronger position when you know where your data resides, what data you're using, how it's being processed. Thereafter, one can actually assess what needs to be prioritized and where the dollars need to be spent. One can't do everything. I think even the regulators probably recognize no company is going to be 100% compliant in this kind of environment, but it's about the efforts you make and the kind of measures you put in place.
And documentation, right? Because the whole point is that you've got to document the rationale for why you did it. And I think if you're looking at it from an investigative perspective, it's spending the time at the outset to work out what those rich data sources are and focusing on those rather than trying to collect and analyze everything. And then within those, I think then it's a risk mapping exercise. So it's trying to do something in the most compliant way possible, but without realizing you can't boil the ocean and you can't tick every box. So I think it's always that sort of triaging exercise. But I think the data mapping and then doing, rather than some companies doing a universal data mapping exercise is going to take years. So it's really around identifying the most fertile sources of information, the most risky, and focusing on those and how one might address those. I think you have to do it in a kind of do a weighted kind of exercise to work out, I suppose, as always, a compliance risk mapping exercise.
Many thanks, Duell and Francis, for a really comprehensive answer. So our next question is, are there any issues that you are finding challenging to advise on as a result of the GDPR, or that are uncertain, and if so, what?
Well, I mean, there's some things in the GDPR which are sort of a bit nightmarish, like the right to be forgotten, which means that, an employee, and we're seeing that even hearing through the grapevine in employment cases where if you've got a quite savvy employee that's being exited, they'll say, oh, I now want to exercise my right to be forgotten, which means you're supposed to go into your systems and expunge all data relating to that person. That's one of the ones where I think my head sort of spins when I think about how one might comply with that. I think, it's also, there are always those challenges. You get a subpoena from the Department of Justice and you are wanting to respond to that, and you're wanting to respond that in a way that's compliant with GDPR. And although we're seeing a lot more sophistication, and I wouldn't use the word sympathy, but acknowledgement that the GDPR is a real constraint, you still don't get a lot of sympathy when it's taking an awfully long time to produce the required information because you're having to go through the GDPR hoops. So I still think that there is always that tension between, the perception of cooperation versus being compliant with GDPR, or whether any of these laws are somehow a mechanism to delay cooperation or not to be as cooperative as possible. So I think that's always the tightrope you tread when you're dealing with US enforcement agencies.
Or the conflict with the Cloud Act, for example.
Correct.
You're poses the dilemma: either transfer from the EU to the US under the Cloud Act, which violates the GDPR, and you could be subject to draconian fines, or if you refuse to transfer from the EU to the US due to the GDPR, that violates the Cloud Act, which opens you up potentially to sanctions in the US. So it's the conflicts with all these various regulations, and then the various topics that Francis was talking about.
And I'd say sometimes, you find it hard to get really robust advice in some jurisdictions about how you should approach this from a legal perspective. And then obviously we would translate the legal advice into a solution. But sometimes, you will develop that solution and you'll present it to the Data Protection Authority and say, this is how we're proposing to address this particular issue. But you can't delay doing anything to wait for them to come back and say yes or no, and sometimes they don't come back. So there's always that little element of uncertainty, which is why we really do think and rethink and debate and test and document what it is we're going to be offering by way of a solution. So if eventually the Data Protection Authority does come back, at least we can say, look, we've really given this as much thought as possible. We've produced a really nuanced, calibrated solution. But there's always that slight cloud hanging over you, again, no pun intended, as to whether the Data Protection Authority is going to agree with your approach. And obviously we've just had that positive result from the German one, but sometimes I know that CNIL, for example, has a lot of resource and is well manned, which is the French Data Protection Authority, but still very, very busy, and frequently you don't get a response from them when you put in your proposal.
Yeah, and we are working on a project now where there's multiple jurisdictions involved, and the DOJ is actually getting involved in the process that we've undertaken. The case that we were talking about earlier, where we've actually segregated private data, and that's as per company policy and also in compliance with GDPR. We have presented that to the DOJ, saying we're going to follow that same protocol in the U.S., realizing that they may not accept that, especially for data that has been collected and processed in the U.S., but at least they're willing to listen and understand our approach and guarantees or comfort that we're providing to them that the data that we are segregating is truly private on the basis of running analysis on that segregated data, so that we can confirm that it is not relevant to the investigation. So they are being receptive, and we're seeing a little bit of movement there.
That's great. Many thanks again for such a comprehensive answer. So our next question is, what would you recommend as the top priority for in-house counsel and compliance departments?
Be GDPR compliant. No, I think it's as Doel said. I feel sorry for. We frequently see long-suffering compliance officers that also had data protection flopped onto their list of responsibilities when they're dealing with a variety of other things. And I think depending on which industry sector you're talking about, it can be incredibly challenging. I think about pharma and life sciences and the nature of the data that they hold. I think about the financial services sector and the nature of the data that they hold as well. And then plus obviously everybody that's dealing with consumer data, so that there are enormous challenges around there. So I'd say the top priority is to undertake that data mapping exercise, so that you can at least prioritize what you need to do in respect to your most sensitive, important data sets, and think about that. And then I think also it's the whole training piece as well. It's just sensitizing your employee base as to the risks associated with not taking this seriously. So I think that's really what it is. I mean, taking into consideration that the whole, cost associated with this, and I think that was one of the arguments. And again, if we go to Brexit, there was a resistance in the UK a little bit, I think, to GDPR because of the costs associated with being compliant to business. That being said, I think people are so aware of their rights around protecting their personal data, and I think it's so enshrined in so many jurisdictions that I don't think you can roll it back. So you've got to find a way to address it and put your money to the most appropriate activity, and I would say that would be data mapping and training.
Yeah, I'd agree with that, and I think it can be daunting, and we have given advice to clients, and it's all about prioritizing and classifying your data instead of trying to, as Francis said, boil the ocean, because for some corporates it's almost impossible to get your hands around every single piece of data. So it's prioritizing and moving forward in that way.
Yeah, I completely agree. The data mapping piece, for sure, having a strategy in place. The other thing I would think of is technical and organizational measures that comes up again and again in the GDPR. And what do they mean by that? It's essentially the controls in place. So you really can't have an effective compliance program without having controls to back it. Right. So really thinking of your access control, running vulnerability checks, testing, monitoring, really testing the system to see whether you're walking the talk and you have the correct protective measures in place.
Many thanks again for such a comprehensive answer. So unfortunately, the clock is against us. So I'd like to thank Francis, Greg, and Doel for a really excellent presentation, which covered a host of salient points. And I think our listeners will have gleaned a lot of useful information from today's webinar. So just as a reminder to attendees, we'll be sending out a link containing the recorded session, so please keep an eye out for that. And as I mentioned at the start, please send the link on to any colleagues who may be interested in today's presentation. And just another note, any unanswered questions will be passed on to our speakers. So I'd like to thank everyone for participating, and I'll hand over to Francis, Greg, and Doel to say their goodbyes. Thanks very much.
Well, I hope you found it informative. Obviously, if you've got any questions, and I saw there's some really interesting ones we didn't get to, we will do our best to answer them, but feel free to contact us with any follow-on questions or comments that you have.
Yes, thanks very much.
Thank you.